Hello. My name's Douglas Guilfoyle, and I'm delighted to be joining you for this guest lecture on command responsibility and the Brereton Report into Australian war crimes in Afghanistan. Now, given current conditions in the world, I'm recording this at home, so please forgive me if you hear a family member or even a small dog interrupt us at any point. But let's make a start. So what do I want to cover in this presentation? So I'd like to speak about the timeline of relevant events, the crimes alleged to have been committed by Australian service personnel in Afghanistan, the controversy that's arisen in Australia over command responsibility in relation to those crimes, and then to go a little more deeply into what are the relevant facts and what was known when and by whom, and how does that play into command responsibility. Then I'd like to look at the applicable Australian and international law, and then I'm going to narrow in on one particular issue that I think is critical in applying those two slightly divergent bodies of law, the issue of the relevant guilty mental state that a commander must have, the mens rea that makes them culpable. And then there's a sort of policy question. When we're looking at issues of command responsibility, how far up the chain of command should that legal responsibility for frontline actions go? And then I want to touch briefly on the issue of complementarity. If there are potentially responsible commanders in Australia and Australia does not prosecute them, could the International Criminal Court, to which Australia is a state party, step in? Well, let's make a start. So our timeline in terms of Australian potential war crimes in Afghanistan begins in 2011 with a case in which there was a court-martial into a so-called civilian casualty incident in which two soldiers were accused of the ordinary crime of negligent manslaughter. That is, they were charged under the Australian Defence Force Discipline Act rather than our statutory law implementing the Rome Statute of the International Criminal Court, which required proving a crime against them that could be committed in Australia. This was an incident in which hand grenades were thrown into a house, and this caused the death of two civilians, or a number of civilians, women and children. And because it was going to be rather difficult to show that this was done as a means of intentionally targeting civilians, making out the war crime of murder or willful killing, then the question arose, well, could it be prosecuted as manslaughter, as an act of negligent manslaughter, as if it had occurred in Australia? And that case became quite complex and ultimately fell apart over this issue of attempting to prosecute a potential war crime as if it were an ordinary crime and as if it had been committed on the territory of Australia and was then prosecuted under the Defence Force Discipline Act. All right, let's move on. In terms of the events that lead concretely to the Brereton Report, which I'll come to in this chronology, in 2013 and 2014, the Defence Department already had internal documents suggesting that there were problems with organisational culture in Australian Special Forces in Afghanistan. This leads to, in 2016, a sociologist being commissioned, Dr. Samantha Crumpfits, to produce a report into the organisational culture in the Australian SAS. And in the process of compiling this report, Dr. Crumpfits was confronted with testimony, admittedly in quite vague and non-specific terms, but from quite a number of people she interviewed, suggesting that there was routine killing of unarmed civilians, or certainly people who were no longer directly participating in hostilities going on. All right, so that 2016 knowledge then leads to the Inspector General of the Australian Defence Force appointing Paul Brereton, a Justice of the New South Wales Court of Appeal, and a Major General in the Australian Army Reserves. And the Inspector General of the ADF is an independent statutory office holder who exercises investigatory powers relating to disciplinary matters and the like over the Australian Defence Force. So this was an inquiry that was obviously conducted, as it were, close to the Defence Force, but independently of it. All right, where does this lead us to? Well, unfolding in parallel with the inquiry, which took 4 years to release its final report, the Australian Broadcasting Corporation begins reporting on what it calls the Afghan files from 2017 onwards. So this reports whistleblower accounts and leaked documents about potential war crimes in Afghanistan committed by Australian forces. And particularly shockingly, in March 2019, the ABC broadcasts helmet camera footage of an Australian SAS trooper executing an unarmed man in a field. And that broadcast was said to have sent shockwaves through the military establishment. Now, at this point, the Brereton Report hasn't been finalised, it hasn't been delivered, and it certainly hasn't been released. And while there's no suggestion that the Brereton Report inquiry was ever going to be discontinued or swept under the carpet, I think these media events make it pretty much unthinkable at this point that there aren't going to be criminal prosecutions of at least a few. So then in November 2019, we have the rather somber moment pictured in my opening slides of the Chief of the Australian Defence Force releasing the Brereton Report and noting its core finding that there is credible information pointing to 39 unlawful killings conducted by 25 Australians. And the Brereton Report recommends that these cases be prosecuted before civilian courts for a mix of reasons, but one of which is that some of the persons who would be suspects in any criminal investigation have already left the Australian Defence Force and would not be amenable to military discipline in the ordinary way. And so some of the cases would have to proceed before civilian courts in any event, so it's perhaps preferable that they all so proceed. To this end, and this is actually announced before the report comes down, Australia establishes the Office of the Special Investigator, so a special investigative branch which will start with the Brereton Report allegations and some of the evidence that's marshalled and begin a new process of criminal investigations with the objective that any cases made out will be reported to the Commonwealth Director of Public Prosecutions for criminal investigation. All right then, let's turn to the question of what crimes are examined or what alleged crimes are examined in the Brereton Report. So it looks at two categories of civilian deaths. First, those that result from what we might consider a very liberal interpretation of rules of engagement, which effectively meant that any male running from a compound of interest could be targeted with lethal force. So in the jargon used by the ADF, these people were referred to as squirters, and there was a presumption that they were direct participants in hostilities because they were running away. And incident reporting or operational reporting tended to use language such as saying that it was believed they were manoeuvring for tactical advantage or perhaps running towards a weapons cache. And that these were, as it were, reasonable things that a soldier in the field might think. The other more clear-cut category that the Brereton Report focuses on in detail is the killing of persons hors de combat or under Australian control in circumstances that are clearly outside the heat of battle, when even if a person had been a direct participant in hostilities at some earlier point, they were now plainly no threat to the lives of Australian forces, and under those circumstances were killed. So that second category is the most clear-cut because there isn't this fog of war element that might surround the case regarding squirters. And as we've said, the report identifies 39 killings which appear clearly unlawful and refers 25 Australian personnel for prosecution. Now, let's just go into this issue of targeting people too liberally further. So there was also evidence of a very worrying practice of carrying throwdowns, which were typically radios or foreign small arms, to plant on unarmed bodies. So that is, if it looked like you'd got it wrong, if the person who had been shot and killed turned out to be unarmed or not carrying anything that looked incriminating, these throwdowns were placed on the body such that in operational reporting, it looked far more compliant with rules of engagement. These people looked much more like they were direct participants in hostilities and therefore valid targets. Well, this is the point I've just made, obviously, that this allowed for a tidied up version of post-operational reporting. Now, one of the things this raises is that it'd be very difficult to prosecute such cases, certainly not impossible, because simply planting evidence on a body after the fact doesn't show your mental state at the time that the person was targeted with lethal force. You might genuinely believe that they were maneuvering for tactical advantage or running to a weapons cache, or that no one should be running away from this compound who wasn't a direct participant in hostilities. So this practice, while it's obviously malpractice, while it's potentially a disciplinary, well, certainly a disciplinary offence, and might say something about the state of mind of the people who engaged in it or the general culture that was prevalent in Australian forces at the time, isn't evidence necessarily of mens rea of murder, of an intention to go out and kill that individual. So the Brereton Report interprets throwdowns in this way, that they're evidence of misreporting, misconduct, and what was called war on higher command, a belief that higher levels of command too far away from the front line were getting too involved, were asking too many questions about difficult cases, and it was just easier to tell higher command what it wanted to hear rather than give accurate reporting of what had happened in the field. And under those circumstances, the Brereton Report sees the use of throwdowns as evidence of a pattern of misconduct, but not evidence of the required mental state for murder. Now, why does all of this give rise to controversy in Australian public opinion, and particularly the veterans community? Well, the key finding for command responsibility is this, which I've quoted at length from page 31. The inquiry has found no evidence that there was knowledge of or reckless indifference to the commission of war crimes on the part of commanders at the troop, platoon, squadron, company or task group headquarters level, let alone at higher levels, including the Allied headquarters in Afghanistan or Australian Defence Quarters in Australia. Nor was there any failure at any of those levels to take reasonable and practical steps that would have prevented or detected the commission of war crimes. The detailed superintendence and control of subordinates is inconsistent with the theory of mission command espoused by the Australian Army, whereby subordinates are empowered and entrusted to implement their superior commander's intent. That is all the more so in a special forces context where high levels of responsibility are entrusted to patrol commanders. So in sum, what this page said was, we are going to refer people for prosecution, but they're not going to be higher commanders. They're not going to rise any higher than patrol commanders, the person actually commanding patrols that went out into the operational environment in Afghanistan and allegedly committed crimes. No one any higher up the chain bears any responsibility. Not only do we say there's no evidence of that, we say that it's inconsistent with the way the Australian Army works, particularly in a special forces context where a very high degree of autonomy is exercised by those out on patrol. And we'll come back to those facts, but certainly the veterans community in Australia, including veterans of special forces, have said that this kind of recommendation, if this is acted on and no commanders are prosecuted, then that is effectively hanging the frontline troops out to dry. Okay, so let's look at the facts then. Now, certainly Afghanistan, as depicted here, is one of the more challenging, possibly the most challenging land warfare operating environment in the world. It's incredibly mountainous, and you have valleys that are potentially profoundly cut off from each other, and very difficult circumstances for communications and certainly for line of sight observation. Now, what factors feed into this circumstance? Well, certainly the report indicates that the Special Air Services Regiment and the commandos in the Australian Armed Forces were developing an unhealthy rivalry with things like kill rates, and that this was particularly on the SAS side of the house. Not all groups, certainly, but some units within the SAS. In addition, certain small groups within the SAS developed a warrior culture, and this relies to some extent on the fact that the SAS operates in these very small patrols of 4 to 6 persons, led by an experienced non-commissioned sergeant. So this would be someone with potentially 10 or 15 years of combat experience who enjoys a very high status in the armed forces in general. And so certainly it's possible for a patrol commander in those circumstances, one of these sergeants, to create a miniature culture within their own unit. And in the worst cases, practices appeared to include blooding, which was actually capturing someone and having the newest member of your unit execute them in order to have their first kill. There was also a division, and the report uses this terminology, between those inside the wire and those outside the wire. So officers and commanders tended to sit inside the wire on base in Afghanistan, but not out on patrol, exercising an overwatch and communications function with the capacity to call in air support if necessary. And those junior lieutenants and captains might only leave the base to inspect a situation after the fact, after all the fighting is over and a compound, for example, is secured. So there very much became a culture that those who went outside the wire and those who were putting their own lives in jeopardy to complete operations enjoyed a particularly special aura, to the point where it was thought a culture developed where really it was not for those who lived their lives inside the wire to challenge or question what happened outside the wire. And this led to, indeed, military lawyers developing a system of boilerplate language where they would finesse operational reports coming from outside the wire. So they looked perhaps more compliant with rules of engagement than in fact they were. So coupled with this, as we've said, the very terrain in Afghanistan, not only do you have the SAS operating in very small units, but the very terrain may deny any kind of line of sight oversight of what's actually happening. And indeed, members of the same patrol might not have complete oversight of everything that occurs on a mission. Further, there's a culture of close holding of information and secrecy, unsurprisingly within the SAS, meaning that information could in theory become highly compartmentalized and kept from superior officers inside the wire. There's also a question of how much power junior officers had over experienced non-commissioned officer patrol commanders. So imagine a situation where a patrol commander has done multiple tours in Afghanistan, has 10 to 15 years fighting experience, a junior lieutenant or captain relatively early in their career has come out on base. And indeed, it's part of the sergeant's job to help train up these new junior officers who are coming out for a couple of rotations in Afghanistan. Further, there is some evidence that where junior officers did push back against practices that they didn't like or that they saw on the ground, they were ostracized and essentially pushed out of the SAS with higher levels of command, trusting the sergeants over these junior officers. So it's not as simple as saying that a junior lieutenant or captain on base is the direct commander of these non-commissioned officers on patrol. Certainly they are in law, and actually if push comes to shove in the military, they should be able to have their orders obeyed. But nonetheless, there is this more complex dynamic that's going on between the non-commissioned officers and the junior officers. All right. And another significant fact here is that misconduct is alleged to have peaked in 2012. As we've said, that one court-martial in 2011 failed to secure any convictions, which was partly about the difficulty of proving the relevant mens rea and also partly complications about trying to prosecute this as a negligent manslaughter case rather than under the international law of war crimes. All right, so what did higher levels of command know? Did anyone know anything that should have put them on notice in a way where they might bear legal command responsibility for those crimes? So I've given a picture already where you could say, well, there appears to be good evidence to suggest that maybe junior officers on base didn't know anything, and the higher levels of command didn't know anything, because all this, whatever happened outside the wire stayed outside the wire. There was a culture of secrecy and compartmentalization, and that knowledge wouldn't necessarily get back to higher command, and certainly not pass all the way up the chain to the Chief of the Australian Defence Forces, pictured here. But one fact that cuts against this is that it was well known that while there was meant to be no alcohol on Australian bases in Afghanistan, the SAS operators, those who went out and conducted operations, were allowed to have a secret bar where they served homebrewed alcohol, and officers in Afghanistan also drank at that bar. So it's difficult to imagine there was no exchange of information or rumours in that setting. And indeed, there were these persistent rumours of criminal or unlawful conduct going on in Afghanistan, without which the Cromford's report wouldn't have occurred, and indeed we wouldn't have got to ABC News reporting, and we wouldn't have gotten to the Brereton Report itself. Third, officers did have actual knowledge of the practice of using throwdowns. So there was knowledge that this practice was going on, and that it constituted at least an attempt to, if not cover up a crime, at the very least was misconduct aimed at misreporting operations in a way that would prevent higher command asking any questions. And maybe that should have been a cause of suspicion. Further, for lawyers, something that I find disturbing and I've already hinted at, was that operational reporting had begun to use boilerplate language to either indicate maximum possible compliance with rules of engagement, or indeed to fabricate evidence of such compliance. And this was being produced by military lawyers inside the wire on base in Afghanistan. And this boilerplate language was being used so frequently that the Australian Army issued a new directive on how operational reporting was to be done. They could tell they weren't getting accurate information, and that certain phrases like manoeuvring for tactical advantage or running for a weapons cache were being used all the time to justify why someone had been targeted with lethal force and killed. And finally, and perhaps most damningly, local complaints were made on a series of occasions by Afghan nationals that their people had been unlawfully killed, and these complaints were received by Australian Army inquiry officers, but were dismissed as either being cases of insurgent propaganda or meritless compensation seeking by locals, and were not investigated further and were not collected into a wider pattern. So how does that kind of evidence fit into the law of command responsibility? Well, let's look first at the applicable international law. And as I'm sure you're familiar with from your readings, the elements of command responsibility are typically phrased as being, first, the existence of a superior-subordinate relationship; second, that the superior failed to take reasonable and available measures to prevent or punish the crimes committed by subordinates; third, we have to have that relevant culpable mental state or mens rea; and finally, the Rome Statute adds a further element of causation, which is, it says that crimes must have occurred as a result of a superior's failure to act. All right, so that's the applicable international law. So how might that play out before the International Criminal Court in slightly more detail? Well, so Article 28A of the ICC statute says that a military commander shall be criminally responsible for the international crimes committed by forces under his or her effective command and control as a result of his or her failure to exercise control over such forces where, and here that phrase effective command and control is really important in defining not just the basis of responsibility, but its scope. A superior isn't required to do the impossible and isn't required to do things they have no power to do. But in any event, we then get this double mental state that the military commander either knew or, owing to the circumstance at the time, should have known that the forces were committing or about to commit such crimes, and that they failed to take all necessary and reasonable measures. Let's turn now to look at the Australian law, and the thing you're going to notice is that it's very similar but not identical to the Rome Statute of the International Criminal Court. So section 268(115) of the Commonwealth Criminal Code deals with the responsibility of commanders and other superiors, and the chapeau element in paragraph 2 is just as we see it in the Rome Statute, and again pinned on effective control. But we then have the two mental states expressed slightly differently. You have actual knowledge, or, owing to the circumstances at the time, there is the question of whether the military commander was reckless as to whether forces were committing or about to commit such offences. We'll come back to that difference in standard. And then we have that same requirement that the military commander has failed to take all necessary and reasonable measures to prevent or repress the commission of crimes or submit the matter to competent authorities for investigation and prosecution. And it's worth bearing in mind in both cases, the ICC and Australian law, that that second limb is easier, right? It might well be easier to report matters than that you have discovered after the fact than to prevent or repress matters, particularly if they've come to light later, as appears to be the case often in the Australian example. All right, so how are we going to apply this law to the facts? So it doesn't matter whether we're looking at the ICC or Australian law. The existence of a superior subordinate relationship is not in dispute. This is a conventional military. Now, it's also obvious that there was no particular action taken prior to 2016, it seems, other than this one isolated case of the 2011 court-martial, which went nowhere. So there appears to be an apparent failure to prevent, punish, or report relevant incidents in the period from 2006 to 2012, when the misconduct peaked, and perhaps right through to 2016, when the Crumford's report is commissioned. Now, we still have this causation requirement. Remember the fourth element, that the crimes occurred as a result of the failure of supervision. Now, there's two possibilities. One is that this is just a formal statement. In fact, that isn't a separate requirement. It's simply the statute expressing the reason why a superior is responsible, because had they done their job, these crimes would not have occurred. Therefore, the crimes have occurred as a result of their failure of supervision. So on one view, actually, the ICC statute doesn't contain a fourth element. It just contains a justification of superior responsibility. The other view that I find perhaps slightly more convincing is that all that one needs to show is that a superior's omission increased the risk of crimes occurring. Now, at the International Criminal Court, the Bemba pre-trial chamber took that approach, though there was a split on this exact point in the separate opinions in the appeals chamber in the Bemba case, with some judges taking the view that effectively there is no requirement to show causation under the Rome Statute, and the others taking this increase in risk approach. But all of this is to say, the real focus is the necessary mens rea. And as the evidence doesn't disclose actual knowledge of murder of civilians by superiors, the question is what is required either by Rome Statute or Australian law for the other mental standards. So before the International Criminal Court, that's owing to the circumstances at the time, should have known, or in Australian law, owing to the circumstances at the time, was reckless. So this is the issue of constructive knowledge. If you can't show actual knowledge, what other form of knowledge do you have to show? When can you say that a superior should have known or was reckless as to whether crimes were occurring and is on that basis liable? Okay, so how do we test this constructive knowledge question in the Bemba case before the International Criminal Court? And here is Mr. Bemba on trial. So Bemba is the only ICC case on superior responsibility. And we have a problem knowing what is required for this constructive knowledge mens rea. First, the pre-trial chamber laid out a pretty stringent test as to when a superior should have known, to some extent following ICTY case law. The trial chamber didn't consider this issue at all because it found Mr. Bemba had actual knowledge of crimes that were being committed, and the appeals chamber didn't discuss mental state at all in its reasons for acquittal. It acquitted on the different question of whether Mr. Bemba had taken all reasonable measures to prevent and punish. And indeed, the appeals chamber did acquit Mr. Bemba, saying that he was back at headquarters, he was structurally and physically remote from the crimes that were committed, and in context, he had done what was reasonable. That was the appeals chamber view. There were some appeals chamber comments in separate opinions on this mens rea issue, but not in a way that's relevant to our discussion. Okay, so insofar as this case law gives us anything, it gives us a test laid out by the pre-trial chamber in paragraphs 432 to 434. and it takes up the deliberately, and I'm quoting here, stringent standard laid out in ICTY cases such as Blaskage, which is that superiors are under an active duty to acquire information about their subordinates' activities and cannot be held liable for them so long as they've exercised due diligence, but conversely cannot plead ignorance, which is the result of negligence. So they say that this is a due diligence standard. What does that mean? If we go into a little more detail, Bemba says the suspect may be considered to have known if, inter alia, and depending on the circumstance of each case, one, he had general information to put him on notice of crimes committed by subordinates or the possibility of occurrence of the unlawful acts, and two, such available information was sufficient to justify further inquiry and investigation. So essentially, you need to have known enough that you should have inquired more. The picture here is of the criminal tribunal for Yugoslavia, where some of the Bemba, which generated some of the jurisprudence the Bemba pretrial chamber draws upon. And so this position adopted in Bemba is consistent with a case they don't cite, but one which I use in the textbook, which is Delalich, that it's enough to satisfy the mens rea that a commander possessed sufficient information to put him on notice of the risk of such offences and the need for additional inquiries. Okay, so where does Australian law come out? So under the Commonwealth Criminal Code, and remember recklessness is the standard here, a person is reckless with respect to a result, and here that's got to be that crimes were occurring, if he or she is aware of a substantial risk the result will occur, and B, having regard to the circumstances known to him or her, it is unjustifiable to take that risk. So one wrinkle on this will be, well, is the relevant result here any war crime or the actual war crime charged? Okay, is it just about potential violations of rules of engagement or potential practices that seem consistent with the liberal targeting of squirters, which would be one type potentially of war crime, or is it with the war crime very specifically charged, say the execution of persons or to combat? So those could be different, or they might be considered to fall within the same kind of category. The bigger question, though, is this question of substantial risk. So was a series of complaints by Afghan nationals enough to create awareness of a substantial risk? And if so, in whom? Who would have had that knowledge? Who would have had that awareness? The complaints appear to have been dealt with ad hoc by individual investigating officers. It wasn't necessarily the case that one of those officers saw all of these complaints. And it's not clear who, at a higher level, had oversight of those reports, or whether it was even one person throughout the entire period, or whether it was multiple people. And let's remember that, in many military situations, you're going to have rotations in and out of the theatre of operations, or even out of higher command roles in headquarters. Those might rotate every 3 to 4 years. So, and as we've said, other evidence points to possible rules of engagement violations, this use of throwdown, and that perhaps could be a basis for superior responsibility. But what would be the underlying crime? And would you have to prove that it had occurred first? So murder, taking each of those incidents of the use of a throwdown and proving a case of murder would be much harder than unlawful killings in the cases of people who'd been detained. So it's not necessarily the case that all of the evidence points to the same crimes, or if we bundle them all up and say, well, there's evidence that something is going wrong here in terms of unlawful killing of civilians, maybe investigating one would have found the other. So it's not clear how this will play out in Australian law. I'd say the core question is this issue of what's required to generate awareness of a substantial risk, and did one person have enough pieces of evidence to have that awareness triggered, that we could sheet it home to them. Then we come to the question of how far up the chain should command responsibility go? So as we've seen, the Brereton Report says, well, it stops at the patrol command level. Above that, people might bear moral responsibility. There might have to be disciplinary or administrative consequences for them, but certainly not criminal consequences. And the separate opinions of Judges Van den Weingart and Morrison in the Bemba Appeals Chamber seem closer to that approach. So they emphasise that the idea of command responsibility is underpinned by effective control, but they construe that very narrowly. They don't mean legal authority, as in a well-disciplined professional military. And they'd say, well, the idea that the chief of a defence force could have effective control over thousands of people is literally nonsensical. What we're talking about is control at the tactical level of what actually happens on the ground. And so they say the primary obligation to prevent, repress, or refer criminal behaviour rests upon the immediate commander of the physical perpetrator, that is the platoon or section commander. They go on to say, in principle, higher level commanders are thus entitled to rely on lower level commanders to keep their troops in check. It is not the task of the higher level commander to micromanage all lower level commanders or do their jobs for them. Now that's a strong statement, but it was only 2 of 5 judges in Bemba in a separate opinion. And let's remember that Bemba was a highly controversial case because it acquitted a commander on the basis that they were structurally and physically remote, and that they therefore had a limit to what they could be regarded as having effective control over and what they could reasonably do to repress frontline crimes. And that drew a lot of criticism at the time. Nonetheless, it is worth noting that these 2 judges would seem to be quite sympathetic to the approach of Bemba and suggest that actually command responsibility is meant to be a principle that applies at the front line and not all the way up the chain of command. This is an unresolved issue, and certainly in historic cases, higher level commanders were held responsible, such as General Yamashita at the end of World War II. The difficulty being, of course, that General Yamashita's trial is considered by contemporary standards to have been potentially highly unfair and even racially biased. All right, so the question then is, well, if Australia doesn't prosecute any military commander or superior, could they be sent to The Hague? Could the Office of the Prosecutor at the International Criminal Court open an investigation and eventually request their surrender? This is a tricky one. So one issue here might be Australia could say, well, we can't prosecute these commanders because we're never going to prove the recklessness requirement in Australian law. So if Australia cannot prosecute superiors because it's incorporated the wrong legal standard, or if it just holds as a policy matter that command responsibility stops at the patrol level, could the ICC step in? Well, the first thing to remember is that ICC admissibility decisions under Article 17 start effectively with the question, is a national system investigating, or has a national system already prosecuted, or has a national system bona fide investigated and decided not to proceed? And if the answer to any of those questions is yes, then the case is inadmissible unless you can show that this has been done to shield someone from genuine prosecution, or that the national state in question is otherwise unable or unwilling to prosecute. Now, how do we apply that in this case? Well, the admissibility jurisprudence under Article 17 focuses on the same person, same conduct test. That is, did the national investigations here for war crimes of this particular commander come to a decision not to proceed? And the answer would be yes. Nowhere in that test does the question, oh, but were they charged with the same mode of participation, seem to come up. Nor does the test of when a state is unable to prosecute seem to contemplate cases where national law is framed differently from the Rome Statute. So none of that's to say that an ICC pre-trial chamber might not answer this question. Yes, if Australia isn't going to prosecute them, we will. But on its face, there seem to be a lot of good reasons to suggest that complementarity might not apply here. If there's a bona fide decision not to prosecute any commanders, then maybe there are no grounds for the ICC to step in. I'd say that the point is uncertain and it's unlikely to be tested. The International Criminal Court is already overstretched. It has had a very controversial last few years. And if in the Afghanistan situation, it can point to Australia and say, look, positive complementarity. A member of the Rome Statute, the International Criminal Court, is prosecuting war crimes as defined in the ICC statute and is doing so against its own service personnel. This is the standard we'd like to see all state parties comply with. Why not take that as a win? Why step into a complex situation and attempt to prosecute very complex cases when you can already say Australia is dealing effectively with that? We don't need to get involved. So for those reasons, I think it's unlikely, but not impossible, that one might see the ICC Office of the Prosecutor look at the situation of command responsibility as regards Australia. And with that, I'd like to thank you for your attention. I hope you found this interesting and useful, and I look forward to receiving by email any questions that you might have. Okay, thanks so much.